Okay, again, hello, welcome this afternoon. My name is Lance Beck. I'm the President and CEO of the Valley Chamber of Commerce. We are pleased to have you joining us today on today's Business Resource Call. Joining us today, we have Angela Hayes, the Senior Legal Counsel with Associated Industries. Thank you, Angela, for joining us. Today's call topic, paid leave benefits within the COVID-19 pandemic crisis here. We're going to go over in depth the updates from HR 6201. We will review many of the updates here in detail and then again cover anything that has taken place since the initial bill update was made on March 25th. In an effort to keep you informed and as the situation develops, Associated Industries team has been monitoring this bill in the legislature since the changes took place originally. So they do have the most up-to-date information on the changes to the Paid Leave Act here. Some basic rules and requests that we have for everyone on the call today. Due to the number of participants we have, we would ask that you remain muted throughout this call. And so we do have the chat box open. Should questions come up, we are going to ask that you hold questions until the end of the call due to the nature of how detailed the information Angela will be going over is. And so please do hold your questions until the end. At the end of the call, we will have some time for Q&A. We ask that you enter your first name, last name, and organization in the chat box, and then your question. And so we'll do our best to answer all of them. We are going to respect the hour time block here that we have slated, as we have a couple back-to-back meetings here today. So should we not be able to reach your question and get you a direct answer, we will be following up after the meeting, which is why we asked for your first name, last name, and organization name. We should have your email addresses in here via the registration process, and so we will follow up with you, connecting you and the team at Associated Industries to be able to make sure we get you the answers to your questions from today's webinar. So with that, I'd like to ask Angela, go ahead and unmute, and we'll let you take it away, as we know we have a lot to cover and not a lot of time. So I'll turn it over to you and allow you to go ahead and share your screen when you're ready.
Great. Thank you very much. I appreciate the introduction. See, it says I can't start screen sharing while the other participant is sharing.
I will fix that.
Okay. And hopefully, I'm assuming that everybody can hear me.
There you go.
Okay, so I'm going to share my screen, and hopefully this will be. So are you guys seeing a single slide?
Yes, we are.
Okay, perfect. All right. Like I said, I have got 3 screens going here, so I just want to make sure I'm on the correct one. So again, thank you very much for having me here today. I'm happy to be here and presenting this information. There is a lot going on right now for employers, so I'm happy to be able to be here. And hopefully the information that I'll be providing to you is helpful. For some reason, my slides are not advancing here. Technical difficulties. 1 second here. Okay. Just a quick disclaimer. Of course, no lawyer would get on here talking without giving a quick disclaimer. The information I'm about to give you is, of course, for general information purposes only, should not be considered legal advice, even though I am talking about legal topics. And of course, it does not establish an attorney-client relationship between myself here at Associated Industries or anybody else out there in the ether attending this seminar today. If you have specific issues that come up after I've provided you with this information, I would strongly encourage you to seek legal advice from your own private legal counsel or somebody else licensed in the law, particularly in the area of employment law, or certainly reach out to myself here at Associated Industries, and I'd be happy to guide you to some resources or see if I can help you myself. The law in this area, as Lance mentioned a moment ago, is changing rapidly. And the regulations and the interpretive guidance that I'm going to be talking about today seems to be consistently under development and under refinement. So the information I'm providing to you today is current through today, but who knows, there may be some additional developments as the rules become finalized a little bit down the road. So this is as current as I could make it for you today. So we're going to jump in talking about a quick overview of the FFCRA, also known as HR 6201 or 10, now I can't remember which it is, but Family First Coronavirus Response Act. We're going to be talking specifically about the paid leave provisions that are in that act. That would be the Emergency Paid Sick Leave Act and the Emergency Family and Medical Leave Expansion Act, or what I've been calling EFMLA or Emergency FMLA. We'll talk about some of the Department of Labor guidance that came out after the law was passed, and then about the Department of Labor regulations, which are actually the rules that have the force of law that have been published now on a temporary basis by the Department of Labor, which are designed to guide an employer on how the law is going to be implemented. And then hopefully, if there's time, we'll have some FAQs with respect to the information we're talking about. So again, a quick overview of the FFCRA and those paid leave provisions. So just a little timeline. HR 6201 was passed or introduced back on March 11th. We are about 1 month out. We are absolutely moving at lightning speed, probably never seen before in our lifetime, and probably maybe never seen again, that Congress is acting so quickly. HR 6201 was passed by the House on March 14th. They brought it back, made some technical corrections and some pretty significant changes to the law, and then essentially reintroduced it on St. Patrick's Day on March 17th. It was passed by the Senate the next day. It was then signed by President Trump on March 18th and became effective on April 1st of 2020. The Department of Labor issued regulations, or what's also called CFRs, just shortly after that on April 2nd. I left that highlighted for myself to go back in and fill that in, but it was shortly after the statute was signed and became effective on April 1st that the Department of Labor quickly issued regulations. And again, those are called CFRs, or the Code of Federal Regulations. Those are sort of the meat that they add to the bones of the statute itself on how the law is going to be implemented. And the Department of Labor continues to issue implementation guidance. So they have a guidance document. I've provided a link to that at the end of this slideshow. I would strongly encourage you to click that link, print out a copy of that Department of Labor guidance document. It's written in kind of a question and answer format. It's really quite helpful. They've got about 79 questions so far. They are consistently adding to the guidance document. So each time you go back and check on it, if you are, like I am, keeping up with it by printing out a copy of it, you want to make sure that you are looking at and using the most recent copy of the implementation guidance, because they have been going back and actually refining and changing some of the responses that they provided in earlier questions, for example. So make sure that you're keeping up with the latest with respect to that guidance document. The guidance document itself does not have the force of law, but it is a good roadmap about how the Department of Labor will interpret and apply and enforce the paid leave provisions of the law and the regulations that they issued shortly thereafter. So the FFCRA, the final law, had several components to it, a very broad range of provisions. There was an appropriation section, there were nutrition waivers, there was the Emergency Family and Medical Leave Expansion Act, or the EFMLA, Emergency Unemployment Insurance Stabilization and Access Act, the Emergency Paid Sick Leave Act, health provisions, there were tax credits, and then there were budgetary effects. So the law was quite voluminous, but the parts that we're talking about today are the ones that are highlighted in red. The EFMLA, EPSL, those are the two paid leave provisions, and then the tax credits for the paid sick and family medical leave is how the employer is going to get paid back when they pay out under either of those two paid leave provisions that I mentioned just a moment ago. So to recap the provisions of the FFCRA, when we are talking about the two paid leave provisions, the Emergency Paid Sick Leave Act and the Emergency FMLA section, they are published in the law with the FMLA provisions being first, and then followed by EPSL, or the Emergency Paid Sick Leave Act. I'm going to talk about them in reverse order, though, because it makes more sense, because the reasons, or the applicable reasons somebody would be entitled to emergency paid sick leave are much more broad than the application of EFMLA. So I'm talking about them in reverse order as opposed to the way they actually appear in the statute, just FYI. So covered employers, for purposes of both of these paid leave provisions, EPSL, Emergency Paid Sick Leave, and EFMLA, or Emergency Family Medical Leave, are private employers that have fewer than 500 employees. So that may be everybody that's on the line today. This is taken as a live count. It is based on the number of employees on your payroll at the time an employee seeks to take leave from you. That your employee count will include full-time employees, part-time employees, temporary employees, day laborers, employees who may be on leave. You do not count independent contractors in that employee count because under the law, they are technically not your employees. And obviously, since this is a live count that is going to be taken each time an employee seeks to take leave from you, an employer's coverage may change as an employer's employee count changes. So right now, maybe you have 450 employees in your organization because maybe you've been subject to some layoffs. Your employee comes to you and asks you for leave. Employee X asks for leave. The employer falls within the coverage of these 2 paid leave provisions because you have fewer than 500 employees. But a month from now, maybe you've been able to hire some individuals into your organization and your employee count is now 510. And employee Y comes to you seeking leave under one of these 2 paid leave provisions. They aren't going to be eligible because you are no longer a covered employer at that moment when that employee is seeking leave. It seems a little bit unjust, but this is how they've come up with it. Now that employee X, who was able to squeak in while you had fewer than 499 employees, is sort of grandfathered in and they get to complete their leave that they started prior to your employee count exceeding 500. The 2 paid leave provisions also apply to public agencies of any size, so that would be your federal and state governments, your political subdivisions, and your schools are all going to be captured regardless of size. So for the emergency paid sick leave provision, that is one of the 2 paid leave provisions in the law. An eligible employee, so an employee in your organization who would be eligible for emergency paid sick leave benefits would be a part-time employee, a full-time employee, a temporary employee, a seasonal employee, a staffing company employee, or a day laborer from an agency. They would be eligible for emergency paid sick leave. They are eligible from day one of employment. There are no other criteria. They don't have to have been with you for 30 days or anything of that nature or work a certain number of hours. They are eligible for emergency paid sick leave benefits from day one of employment if they have a qualifying reason. Now, a full-time employee is eligible for up to 80 hours of paid leave for a qualifying EPSL reason. And a full-time employee is somebody who is regularly scheduled to work 40 or more hours per week. A part-time employee will be eligible for the number of hours that that employee works on average over a 2-week period of time. And a part-time employee is any employee who is not considered full-time. So you may consider your full-time employees to be 30 hours a week employees, but in this circumstance, those would only be considered part-time employees because they're working less than 40 hours a week, and they're only going to get a pro rata or prorated number of paid sick leave hours under this law. Some employees may work a variable work schedule, and you're going to need to calculate the average number of hours that they work per day over a 6-month period of time if they've been with you that long, or however long they've been with you, whichever period of time is shorter. Emergency paid sick leave does not carry over at the end of the year. These 2 paid leave provisions will sunset in the law on December 31st of 2020. So at the end of this year, they will not continue on, and there will be no benefits available to anybody after that time unless they extend this for some reason. But let's count on it ending on December 31st of 2020. So those EPSL hours that an employee has, unlike our Washington state paid sick leave hours, for example, that you have to carry over at least up to 40 hours every year, these benefits will essentially evaporate on December 31st of 2020. Moreover, if you have an employee that leaves employment prior to the end of the year, you do not have to pay out any available emergency paid sick leave hours that they may still have available to them on separation of employment. There are 6 qualifying reasons that an employee may be eligible to get up to that 80 hours of emergency paid sick leave from your organization. As a qualifier for every one of these rules, the employee must be unable to work or telework for one of the following reasons. So that's always a key that you come back to. Is the employee unable to work or unable to telework? And if so, then they may be qualified for benefits. If the employee is able to telework, i.e. the employer will provide the employee, there is work for the employee to do, and it can be done from a location other than the regular work site, and the employer is making those tools available or giving the employee permission to do telework, then they are able to telework. It is not optional for the employee to decide whether or not they want to telework. If the telework is available to them, then the employee is able to telework and would not be eligible for emergency paid sick leave under any of these provisions. So you'll hear me refer back to the employee is unable to work or telework for one of the following reasons. First reason, employee is subject to a government quarantine or isolation order related to COVID-19. This was originally published. All of the legal hubbub surrounding this rule thought it would be very narrowly interpreted, meaning that you essentially had to be personally issued a quarantine order by state or federal authorities isolating you or quarantining you because of COVID-19. And I always use the example of those cruise ship passengers. Those individuals were actually subject to a government quarantine when they were disembarking from those various cruise ships. They were taken away on buses and sequestered away at an Army base for 2 weeks while they went through a quarantine process. They were actually subject to a government order of isolation or quarantine. Those are very rare, and we thought that that was what the Department of Labor meant with respect to this rule. They have come out since that time in that guidance document that I mentioned earlier, around questions 20 to 23 or 24, talking about what an isolation order means. And then the regulations came out, and again, those have the force of law, and also decided they were going to interpret this a little more broadly, meaning things like shelter-in-place orders may also qualify as a government quarantine or isolation order. So there is a lot of confusion as to when this particular provision will apply. I think what you always need to come back to, though, with respect to this is, for example, in Washington, where we have the Stay Home, Stay Healthy order and the proclamation from Governor Inslee, which essentially shut down non-essential businesses. If you have an employee that is seeking to take leave under this particular provision because they say, I'm subject to the Stay Home, Stay Healthy order, but the non-essential business has essentially closed or had to lay off all its workforce because it can no longer operate, then the employee is not going to be eligible for any type of paid sick leave under this provision because there is no work for the employee to do. There is no work for the employee to take leave from. And therefore, the employee, even though the business may be closed because of the Stay Home, Stay Healthy order, the employee will not be entitled to take emergency paid sick leave under this provision. So I think, the short answer to this is that there's a lot of confusion as to when this applies. I think it's going to be narrowly applied. And I think the circumstances under which this is going to operate is probably going to be fairly narrow. Again, because of the limited time that we have, I would strongly suggest that you go to the Department of Labor guidance document, again, the link to which I provided at the end of this slideshow, and take a read through the number of examples that the Department of Labor provides when they talk about whether somebody would be entitled to emergency paid sick leave under this reason number one. Because I think it is actually going to be fairly narrowly applied, again, mostly because, like in our state, non-essential businesses have essentially ceased operations. And in that case, again, there is no work for the employee to take leave from, and therefore they are not going to be entitled to benefits, even though the reason they don't have work is because of the Stay Home, Stay Healthy order. They may be entitled to benefits under, a different, there are other reasons here, and we're going to talk about those. So again, second reason that an employee may be entitled to take emergency paid sick leave under this new law is that the employee is unable to work or telework because the employee has been advised by a healthcare provider to self-quarantine due to COVID-19 concerns. Key to this is that they have to have a healthcare provider involved and making this recommendation. It's not enough to have a general statement by healthcare providers to say all asthma sufferers out there. I saw, Dr. So-and-so on TV who advised that if anybody who has asthma should stay out of the workplace because of concerns about COVID-19 and somebody's vulnerability. That isn't going to cut it. It has to be a specific directive by a healthcare provider for the employee, instructing them to self-quarantine due to COVID-19 reasons. And that means, again, that the healthcare provider, it could be a doctor, it could be a nurse practitioner, or it could be another healthcare provider that is recognized under the Family Medical Leave Act provisions that is able to provide medical advice or direction. That healthcare provider has actually advised the employee to self-quarantine based on a belief that either the employee has COVID-19, the employee may have COVID-19, or the employee is particularly vulnerable to COVID-19. So again, an employee has asthma or diabetes, or maybe they're of a certain age, maybe they're pregnant, and all those conditions may make them more vulnerable to COVID-19. If the employee's healthcare provider has advised them to self-quarantine, they may be eligible then for up to 80 hours of paid leave from the workplace because of that advice that's been provided to the employee. Now remember, if the employee is in self-quarantine, but they are able to telework, Because say they have a job that allows them to, like myself, I can easily work from home because I'm conducting most of my business by email and by telephone. Even if I had to self-quarantine on the direction of my healthcare provider, I still wouldn't be eligible for emergency paid sick leave benefits under this because I am able to telework. If, however, say I had COVID-19 symptoms and they were overtaking my ability to sit up and function and think, and I was actually very ill with COVID-19, in that circumstance, I wouldn't be able to telework, even though that work was available to me, but my physical symptoms were preventing me from doing so, and therefore I would be eligible for paid leave benefits under this particular reason. But generally, if an employee is otherwise, well enough to be working from home, even if they have been advised to self-quarantine, they wouldn't be eligible for paid leave benefits because they are, quote, able to telework. I've had a lot of employers call and ask questions about, we have an employee who is unilaterally or just deciding on their own because of an underlying health condition that they have that they aren't going to be coming into work for, say, 14 days. They're going to self-quarantine because they are either worried that they will catch COVID-19 from a coworker or somebody out in the public, or that they may have symptoms themselves and they don't want to go out and infect anybody else, which is noble. But in order to qualify for benefits under this particular section, they would have to have a healthcare provider step in and advise them to be self-quarantining. They can't just unilaterally decide to self-quarantine and get benefits under this particular reason. Third reason that somebody might qualify for emergency paid sick leave would be that the employee is unable to work or telework because the employee is experiencing symptoms of COVID-19, which would be things like dry cough, fever, shortness of breath, and then any other symptoms that are recognized by the CDC, and the employee is seeking a medical diagnosis. So leave is going to be limited under this circumstance to the time that the employee is unable to work or telework because they are taking affirmative steps to obtain a medical diagnosis. That would include things like time spent making an appointment, maybe waiting in line for 3, 4, 5 hours to get tested out of the fairgrounds, attending appointments. If the employee is able to telework during this time, though, they are not eligible for emergency paid sick leave. So if the employee goes and gets tested, they're sitting in their car, they're waiting to get that test done, they're not really probably going to be able to telework from the car. But say then they have to stay home for 5 days while they're waiting for those test results to come back, they probably are going to be, and if they're not otherwise, experiencing very significant symptoms, they could continue to perform telework, then the employee would not necessarily be entitled to emergency paid sick leave benefits during that time period if they are actually able to work. Again, maybe they have symptoms that are really so significant that they're needing to get rest and recuperation and are not able to fully function at home. In that case, they probably are unable to telework due to those symptoms that they're having. The employee can continue on this leave while they're experiencing any COVID-19 symptoms that are preventing them from doing teleworking, or they may continue taking leave after testing positive for COVID-19, regardless of the symptoms that they're experiencing. So if the employee tests positive for COVID-19, even though they may not be experiencing symptoms currently, they would be entitled to paid sick leave during that period of time for up to those 80 hours. If the healthcare provider is advising self-quarantine, which I'm sure that they would do if somebody actually tested positive and had those symptoms. So reason number 4 that an employee would be qualified for emergency paid sick leave is if the employee is unable to work or telework because they are caring for an individual who is either subject to that quarantine or isolation order or shelter in place order, or the individual has been advised by their healthcare provider to self-quarantine due to concerns related to COVID-19. Now, the employee in this circumstance must have an actual relationship to the individual that they are providing care to. So it can't just be, sort of a random stranger. I'm not really sure why that would come up, but the regulations make clear that the employee actually has to have some kind of relationship to the individual. It doesn't have to be a family member, but of course, a family member would qualify as an individual that the employee would be providing care to. It could be a roommate. It could be somebody that the employee is in a significant relationship with, that creates an expectation that the employee would provide care to the person if they were quarantined or self-quarantined. Now, the individual receiving the care must be subject to the state or federal isolation order, or the individual must have been advised by the healthcare provider to self-quarantine based on the belief that the individual has or may have or is particularly vulnerable to COVID-19. So again, you may have employees that come to you and are seeking to get some emergency paid sick leave because the employee says, I live with somebody who is diabetic or has asthma or has COPD or some other condition that makes them particularly vulnerable. And I'm afraid that if I'm going back and forth from work, I'm going to bring something home to them, that vulnerable individual. Again, that's not going to qualify them for emergency paid sick leave based on those reasons. If the employees, the person at home, the vulnerable individual, has been advised by a healthcare provider that they are particularly susceptible to COVID-19 and that they should self-quarantine, and therefore the employee is having to be home providing care to that individual, then they may fall within the purview of this particular reason. But the employee, again, can't just unilaterally decide that they aren't going to come to work because they don't want to jeopardize the health and safety of somebody at home. That person at home has to have been advised by their healthcare provider to self-quarantine because of their vulnerability to COVID-19. The fifth reason that somebody might qualify for emergency paid sick leave is one that probably a lot of people are experiencing right now, and that is that the employee is unable to work telework because they need to care for a son or daughter because that child's school or place of care is closed, or the regular child care provider is unavailable due to COVID-19 related reasons. And now that the state of Washington has shut down all the schools for the remainder of the school year, there may be a significant number of employees that are needing this type of leave. An employee is entitled to emergency paid sick leave under this provision only when the employee needs to and is actually caring for the child. The employee is not going to be entitled to emergency paid sick leave payments if there is another suitable individual at home that is able to care for the child. So like both parents can't be home caring for the child, the employee isn't going to be qualified to receive benefits under the emergency paid sick leave provisions if there's another person at home caring for the child. It could be a grandparent, it could be a neighbor, it could be, the regular babysitter, it could be, somebody else. So the employee has to be the person that is going to be home and actually providing care to the child. Child, for both purposes of emergency paid sick leave and emergency FMLA that we're going to talk about in a minute, and the reason for emergency FMLA looks a lot like what we're talking about right here, can include a child over the age of 18 if that child is incapable of self-care due to a disability. So somebody may have a child at home that is, say, 20 or 21 years old. Maybe they normally have a care provider in the household during the day while the parent is at work, providing supervision and care to that adult child who is incapable of caring for themselves. But now that regular care provider is unable to provide care because of COVID-19 related reasons. And the employee then needs to be at home to provide care to their adult son or daughter who's not able to care for themselves. The regular care provider does not have to be a licensed care provider, and it does not have to be somebody that's receiving compensation. So maybe the employee has an arrangement with a grandparent to watch the child, several days a week after school, or there's a local babysitter that's providing that care. Again, the child care provider that is unavailable due to COVID-19 reasons does not have to be a licensed child care provider, and it does not have to be a paid care provider. It's just somebody who is regularly providing care to the child that is no longer available due to COVID-19 related reasons. There is a sixth kind of catch-all reason that somebody might qualify for emergency paid sick leave. It really isn't in effect currently. It's basically a catch-all provision for the government that in the event they needed to expand the reasons for emergency paid sick leave, they could go back under this and do it. So the employee is experiencing any other substantially similar condition that is specified by the Secretary of Health and Human Services. Basically, this rule doesn't exist. They haven't identified any substantially similar conditions, so no employee is going to be able to invoke reason number 6 as qualifying them for emergency paid sick leave. So basically, we're talking about rules 1 through 5 that we just mentioned. How much is an employee going to get when they take emergency paid sick leave depends on the reason that they are out of the workplace. An employee who takes leave for emergency paid sick leave reasons 1, 2, or 3, that's basically where the employee is subject to the quarantine order, or they themselves have symptoms, or they themselves have been advised to stay self-quarantined. They're going to get 100% of their regular rate of pay up to a maximum of $511 a day, maximum of $5,110 total for that 80-hour period of time for that full-time employee. When an employee takes leave for emergency paid sick leave reasons 4, 5, or 6, which doesn't basically exist at this point, the employee is going to be entitled to 2/3 of their regular rate of pay, up to a maximum of $200 a day or $2,000 in total. So they get a little bit less when they're taking reasons, or they're caring for somebody else, or they're caring for their child who's out of school. Regular rate of pay includes things like commissions, piece rate compensation, and tips if the employer takes a tip credit, which you shouldn't be doing in the state of Washington if that applies to you. Instead of using the work week in which the employee uses leave, the employer is going to calculate the regular rate by using a 6-month look-back period or the entire period of employment, whichever is shorter, and coming up with a regular rate of pay over that period of time. I'm referring you here to the actual regulations. If you Google 29 CFR 826.25, and you could put in FFCRA, then that statutory reference there, it will provide you with the details on calculating the regular rate of pay for an employee who is taking leave under emergency paid sick leave. Now, emergency paid sick leave, and how does that interact with the other myriad of leaves that we have here in the state of Washington? Because, an employee may have employer-provided leave benefits as well. Maybe they have some paid sick leave through the state, the new Washington state paid sick leave provisions, or maybe they have a bank of PTO or vacation leave built up with their employer. The employer must allow an employee to use emergency paid sick leave first for a qualifying reason if the employee so desires. The employer can't require the employee to use their accrued leave under an employer-provided policy or plan first. So the employer can't have a policy or can't require an employee to, hey, you're going to have to use all your PTO or vacation first before you can tap into or be qualified to use emergency paid sick leave benefits. It's up to the employee to decide which benefit they want to use first. And, in the case of, being out of the workplace because of the care of a child or caring for another person in the household, where they're only getting 2/3 of their regular rate of pay, they may want to dip into their PTO or vacation if the employer allows it to utilize those benefits for their full wages. Any leave that an employer provided to an employee prior to April 1st, and I have had employers that generously, when this all started, say in about March, and they had employees that were already out of paid sick leave, but they wanted the employees to be out of the workplace because they were maybe exhibiting symptoms of COVID-19. So an employer put sort of an ad hoc policy or temporary additional paid leave policy in place that said, we're going to give you an additional 2 weeks of paid leave so that you can be out of the workplace safely and not infect the other employees. If the employer provided something like that to an employee prior to April 1st, an employer is not going to be able to get a tax credit for those benefits that they provided before the law took effect. So any leave payments provided to an employee prior to April 1st are not going to be eligible for the federal tax credits. Likewise, if an employer decides to pay an employee more than what would be what is prescribed under the federal law. So for example, if the employer is going to pay an employee their full wage when they're out caring for another person who's suffering from COVID-19, or when the employee is out taking care of their child because their school or daycare is closed, and instead of paying the employee just their 2/3 rate, they're going to go ahead and make the employee whole by paying them their full weight or their full freight. The employer is not going to be entitled to a tax credit for that extra 1/3 payment that they made to the employee. They could still get a tax credit for the maximum amount allowed under the law, but they aren't going to get a benefit or tax credit for paying anything over and above what the federal law would permit. Okay, we're going to shift gears and talk about away from the Emergency Paid Sick Leave Act and now looking at the EFMLA. There may be employers on the phone that are used to classic or traditional FMLA leave needs. If you are an employer that has 50 or more employees in your organization for 20 or more calendar work weeks in the preceding year, and somebody needs leave for a serious health condition and all of that, you may be very used to FMLA. This is sort of an expansion of that. It does not provide employees with any additional weeks of FMLA leave over and above what they would be entitled to under what I'm calling classic FMLA leave. It simply broadens, or it provides another reason, qualifying reason, that an employee may be entitled to take FMLA leave. And it also captures other employers who don't traditionally have to deal with FMLA because they are too small. So covered employers, for purposes of this provision in the FFCRA, the Emergency Family Medical Leave Act, a covered employer, again, is just the same as described before. It is a private employer that has fewer than 500 employees, We look at that employee count at that snapshot in time when the employee seeks to take leave from the employer. So your employer coverage may change over the period of time, depending on if you have more than 500 employees in your organization or fewer than 500 employees in your organization. If you are currently an FMLA employer, where you traditionally have to have 50 or more employees for 20 or more calendar work weeks, those types of provisions, those provisions or requirements do not apply to emergency FMLA. It will continue to apply to your classic FMLA leave reasons, but not to this particular reason under the emergency FMLA. Likewise, if you are used to dealing with FMLA and you know that one of the requirements is that an employee who is seeking to take FMLA leave must be working within 75 miles of another 50 employees, that 75-mile radius rule does not apply to emergency FMLA only. It will continue to apply to your other classic FMLA reasons. Also, as a covered employer would be a public agency of any size. Again, that would be your state or federal government entities, schools, political subdivisions. Eligible employees for purposes of emergency family medical leave only would be any full or part-time employee that has been on the employer's payroll for 30 calendar days prior to the need for leave. Little bit different from emergency paid sick leave that we were just talking about, where you're immediately eligible for it from day one of employment. To be eligible for leave under the Emergency Family Medical Leave Act, you have to have been with the employer for 30 calendar days prior to the need of leave. Now, classic FMLA eligibility criteria that some of you employers on the phone may be used to, that 12 months, that the employee's been with you for 12 months, they've worked 1,250 hours, and again, they work within 75 miles of another 50 employees. Those criteria do not apply to somebody who is looking to take leave under the Emergency Family Medical Leave Act. They do continue to apply for all those other classic FMLA reasons. So you have an employee that needs to go out for surgery, totally unrelated to COVID-19. Those traditional or classic FMLA requirements will continue to apply to that employee's need for leave. So if you are a classic FMLA employer, you may be dealing with two different eligibility criteria. Likewise, if you have never been an FMLA employer because you've never been big enough to be one, you have fewer than 50 employees in your organization, you are now having to deal with a sort of pseudo FMLA leave that you've never had to deal with before. There is one qualifying reason that an employee would be entitled to take leave under the Emergency Family Leave Act, and that is that the employee is unable to work or telework due to the need to care for the employee's son or daughter whose school or place of care has been closed, or the child care provider is unavailable due to a public health emergency specifically relating to COVID-19. So this sounds just like emergency paid sick leave reason number 5. So there is some crossover between those two leave reasons. The DOL has clarified again that the child may be somebody over the age of 18 who is incapable of self-care. And as you'll notice in that last bullet point, EFMLA and EPSL reason number 5 may overlap. Now, traditionally, let's talk about what the employee would be entitled to. So under EFMLA, the employee has to be out of the workplace because they can't work or telework because they're home caring for their child because the school or daycare is closed. An employee would be entitled to up to 12 weeks minus any other FMLA leave that they've already used in their FMLA year. So say you are an FMLA employer, you have an employee that was just out for 4 weeks for a back surgery and recovery time. And now the employee's back at work and suddenly the child's school or daycare is closed and the employee needs to be off work again. They only have 8 weeks of FMLA available to them, meaning they would only have 8 weeks available to them to take off to care for the child who's out of school or daycare, for example. Okay, so employees are entitled to up to a maximum of 12 weeks for emergency family medical leave. It does not add to any FMLA leave that they had previously. Again, still just 12 weeks that they would be entitled to. Traditional or classic FMLA is unpaid leave. This leave, this one qualifying reason for emergency family leave, is partially paid under these temporary federal rules and regulations. Weeks 1 through 2 of emergency family medical leave for care for your child whose school or daycare is closed is unpaid. So the first 2 weeks of leave are going to be unpaid. The remaining 10 weeks, weeks 3 through 12, are going to be paid at 2/3 the employee's regular rate of pay for the number of hours that the employee typically works each week, capped at $200 a day, or $10,000 total for that 10-week period of time for which they are receiving payment. The first 2 weeks that are unpaid, though, an employee may choose to utilize emergency paid sick leave during that period of time. Again, that reason number 5, where they would be getting 2/3 their regular rate of pay, up to $200 a day, so that they have some income coming in during those first 2 weeks of FMLA that would be unpaid. FMLA will be running during that time period, so you have these 2 leaves running concurrently, but the employee may choose to substitute that unpaid period of time with some payment. Likewise, the employee may also opt to utilize an employer-provided benefit during that time period as well. So if the employee has PTO, vacation, sick leave, something of that nature, the employee could tap into that as well. While the employee is taking emergency paid sick leave or EFMLA leave, the employer is required to maintain the employee's health coverage under any group health plan on the same terms and conditions as if the employee had remained in the workplace. And that means that if the employee is paying a portion of their premium, they must continue to do so while they are out of the workplace. Typically, the employee's share of the premium is going to be paid by the method that is normally used during any paid leave, presumably a payroll deduction. But if the leave is unpaid, so maybe those first 2 weeks of FMLA leave, for example, if it is unpaid, or the employee's pay during their leave is insufficient to cover their premium payment, the employer can obtain payment in accordance with, I've given you the statutory reference. This actually comes out of the FMLA, classic FMLA, I'll call it. So if you Google 29 CFR 825-210C, if you just type that into your Google search engine box, and probably typed in FMLA and hit click, it'll take you to that portion of the regulations that details how an employer is to collect an insurance premium from an employee when they're out of the workplace on leave. So you do need to maintain their health insurance while they're out of the workplace, but they do need to continue to pay their portion of the premium if that is applicable. Now, job restoration, an employee will be entitled to return to the same or equivalent position that they held at the time their leave commenced. That applies to both leave taken under emergency paid sick leave or emergency family medical leave when the employee is going to be gone for up to 12 weeks. Employers that have fewer than 25 employees in their organization may be excused from these job restoration requirements where an employee takes leave due to school closure or childcare needs. So just for that one reason, you can be excused from the job restoration requirements if the employee's position no longer exists following leave due to operational changes that were caused by the public health emergency. So maybe you had to do quite a bit of downsizing and that employee's position went away anyway. You aren't going to have to restore them to that position. And you have to make reasonable efforts to restore the employee to an equivalent position at the end of leave. So I would suggest that you document what types of jobs you had available to the employee when they were about to return from leave. And if there is nothing available, I would make documentation notes of that. And the employer is going to have to make reasonable efforts, whatever that means, to contact a displaced employee for up to 1 year after displacement if an equivalent position becomes available. And likewise, as a best practice, there is no guidance on the employer documents any of this, but I would suggest that you do make some kind of documentation about how you were achieving each of these criteria so that in the event somebody comes back later and makes a complaint that the employer did not restore them to their position, that the employer can justify that by saying, we had fewer than 25 employees and we met these criteria, and here is our documentation to demonstrate how we met that criteria. I'm going to talk a little bit about the DOL guidance and regulations that have been published since the law took effect on April 1st. One of those is something called the small business exemption. and I've had a lot of employers think that, well, since I have fewer than 50 employees, we are exempt from all of the provisions of these two paid sick leave, new paid sick leave laws. And that is actually not the case. So small employers, which would be those employers that have fewer than 50 employees in their organization, it would include nonprofits and religious organizations, again, that have fewer than 50 employees, may claim an exemption from emergency family leave, that 12 weeks of leave when somebody has to be out to care for their child, and emergency paid sick leave number 5, again, that same child school closure daycare reason. You can claim an exemption for your obligations under those two provisions and deny an employee's leave request if the employer's authorized officer determines that one of the following criteria applies: that the leave that was requested under either EFMLA and or emergency paid sick leave number 5 would cause the business's expenses and financial obligations to exceed its revenues and cause the business to cease operating at a minimal capacity, or the employee that is seeking leave, their absence would entail a substantial risk to the business's financial health or operational capabilities because the employee has specialized skills, knowledge, or responsibilities that can't possibly be replaced. Must be great to be indispensable like that. Or there are insufficient workers who are able, willing, and qualified to perform the labor or services that were provided by the employee or the employees who have requested leave under one or both of those provisions, and these labor or services are needed for the business to operate at a minimal capacity. Important for these small businesses to remember that the exemption, your ability to deny leave, applies only to somebody who is seeking leave under EFMLA or EPSL reason number 5, that school closure or childcare needs. Small employers are not exempt from providing emergency paid sick leave for any of those other reasons, that 1, 2, 3, 4, and non-existent number 6. If the employer denies a leave request based on this exemption, the small business exemption, I strongly encourage the employer to document how they meet one of those above criteria and retain that documentation for at least 4 years. You don't send it into the Department of Labor. This suggests to me that it is going to be a retrospective look, that if somebody were to file a complaint and the Department of Labor came back and audited you or questioned the employer's denial, you would want to be able to produce these records about how the authorized officer of the corporation was able to meet those criteria. Small employers are still required to post the mandatory notice of paid leave rights, which if you Google again, mandatory leave rights poster for emergency paid leave, you should all have that poster posted in your organization currently. That's the employer's notice requirement. Small employers, even if you're going to seek an exemption or seek to deny leave to employees under this, you're going to have to still post that poster. Okay. If a work site, so I'm going to talk just quickly about closed work sites, furloughs, reduced work hours. If a work site is closed because the employer is lacking necessary business to keep the place open, or because of the shelter-in-place order that closed down all the non-essential businesses, or you have an employee that is laid off or furloughed, the employee is not going to be entitled to paid leave benefits under emergency paid sick leave or EFMLA, because again, there is no work for the employee to do. And if there is no work for the employee to do, because they've been laid off or furloughed or the work site has closed, even if that is due to that shelter-in-place order, there is no work for the employee to take leave from. And their remedy then in that case is to go to employment security and apply for unemployment benefits, not to get paid leave under one of these two provisions. If an employee is on emergency paid sick leave or EFMLA and thereafter the work site closes, or the employee's work group is laid off and the employee's job, it no longer exists, for example, the employer is going to have to pay the employee for any leave that they have taken up to the date of closing. But as of the date or closure or layoff, the employee is no longer entitled to benefits under emergency paid sick leave or EFMLA, again, because there is no work for the employee to be taking leave from, and the employee may thereafter be eligible for unemployment. So their benefits shift from EPSL or EFMLA to unemployment benefits. Finally, if an employee's hours are reduced while they are on leave, so maybe when they took leave, they were working 30 hours a week, and the employer's having to make cuts, and their work hours, that they are going to be coming back to is reduced to, say, 10 hours, they aren't going to be entitled to payment for those reduced or missed work hours, that 20 hours that they're losing because of the employer's decrease in hours. An employee needs to provide notice of leave to the employer. I'm not going to go into this in great detail because I want to make sure I can get through all of this, but I would read through the employee's requirements for requesting leave from the employer. Employers have been asking a lot of questions about what kind of documentation can we get from an employee to justify their need for leave. They do need to provide something to the employer in writing. You'll see it outlined there in bullet number 2 for all paid leave requests that an employee is going to make. The employee is going to have to provide to the employer in writing the following information: their name, the dates they're requesting leave, the qualifying reason for leave. So it's, EPSL reason, 1, 2, 3, 4, 5, or emergency family leave, and some type of oral or written statement that the employee is unable to work because of the qualified reason for leave. In addition, they will need to provide some documentation or additional information to the employer depending on the type of leave that is requested. The general theme of all of these regulations is that the employer can require information to be provided to them, but there's not a lot of actual documents that the employer can request. So these 4 bullet points outline the different types of information that an employee is going to need to provide to the employer to justify their need for leave. In addition, though, if the employer wants to get paid for the leave payments that they're making to the employees, they are also going to have to collect additional documentation from an employee. I have provided at the end of the slideshow the guidance document from the IRS that outlines the documentation that the employer can require to substantiate the employee's request for leave, and the documents that the employer is going to have to maintain to claim those tax credits for those payments. So don't be shy about asking for this documentation. And in fact, if the employee refuses to provide the documentation that you would need to justify or to make the tax credit request from the IRS, you can deny their leave and leave payments. So the employee does have to comply if they want to get that paid leave. They do have to comply with your request for documents that are going to substantiate your IRS tax credit requests. So again, to claim your tax credits, I would again strongly suggest that you talk to your accountant, your tax professional, and or go to the IRS site that I've listed at the end of the slideshow. It will outline there the documentation that you need to maintain, the records you need to maintain in order to substantiate your request for those tax credits. Likewise, if the employee's need for leave has to do with a child's school or daycare closure or the unavailability of the regular child care provider, the employee is going to have to provide a statement to the employer that is outlined here in these bullet points. Again, they're going to have to provide the employer with information about the name and the ages of the child, a representation that there will be no other person providing care for the child. It makes it clear that both the Department of Labor and the IRS has shut the door on multiple people being home at the same time caring for the kids. Only one person can be home caring for the children and receiving payment under these provisions. Increments of leave. The default stance under emergency paid sick leave and EFMLA is that the leave has to be taken in full day increments. You can't take leave in an hour at a time or 2 hours at a time, generally. Once the employee starts taking paid leave under emergency paid sick leave or EFMLA, the employee is going to have to continue to take that leave each day until the employer either uses the full amount of paid sick leave available to them or they no longer have a qualifying reason to take paid leave. The basis for this full day increment requirement is based on the intent of these statutes, which is to provide such paid sick leave as necessary to keep the employees from spreading the virus to others. So if you were allowing employees to use their leave in increments of leave in 1 and 2 hours, and they were kind of coming and going from the work site, for example, that defeats the entire purpose of providing these paid leave provisions so that employees can stay out of the workplace and not be infecting one another. which brings us to, can an employee take their leave on an intermittent basis? And it depends on where the employee is actually performing their work. A teleworking employee may take intermittent leave under either emergency paid sick leave or EFMLA in any increment agreed to by the employer, as long as the employer and the employee agree. So an employee that is working from home can reach an agreement with the employer that the employee will work intermittently and then they will take some of their leave intermittently. The DOL says that's fine when you're teleworking because you're not going back and forth from the work site, risking that you're going to infect other employees at the work site. So they will allow intermittent leave as long as it is agreed to between the employer and the employee. Both parties have to agree to the intermittent leave. If the employee and employer reach an agreement, the law does not require that the agreement be in writing, but I would strongly suggest that the employer and employee agree in writing as to what the intermittent schedule is going to be, what the increment of leave will be that will be used, like we're going to measure this in 1 hour increments or half-day increments or however the employer is going to do it. You will only be able to deduct from their leave availability the amount that they actually use. If, however, an employee cannot telework, but they can go to their usual work site and perform work, say they're a bank teller, and they can't obviously telework, but they can work at the usual work site, they would only be able to use intermittent leave if the employer and employee agree, and only if they are taking leave because their child's school or daycare is closed. An employee who has to go to the work site to work cannot use intermittent leave if the reason they're taking leave is because of a COVID-19 reason that they are either infected with, or they've been advised to self-quarantine, or they're taking care of somebody else. The DOL has slammed the door on that. They do not want employees going back and forth from a work site where there is any risk that they will be infecting other individuals or members of the public. So if the employee's work requires them to be at the work site, the only reason that they would be allowed to take intermittent leave upon agreement by the employer, which is always required, is if the reason for leave is because their child's school or daycare is closed. So maybe they can come to work for 4 hours a day, and then they have to go home and take care of the child because maybe they're trading off with the other parent, and then the other parent's going to go to work and they have to be home taking care of the little kids. Then they could use that leave intermittently, but only if they're going back and forth from the work site and using leave to care for the child whose school or daycare is closed. We talked a minute ago about coordinating an employee's benefits under emergency paid sick leave with other employer provided benefits. I'll let you take a look at that, at those bullet points, because I'm almost out of time here. And a couple of FAQs. You can go back and take a look at these. I think I've essentially answered them here and or through our discussion here today. As Lance said, if you have additional questions, please do feel free to email those. I can't promise you that I'll be getting back to you quickly because we've had a real influx of email and calls from our members that we are really trying to tend to, but I will do my best to get some responses back. Finally, here are the resource documents that I was mentioning a moment ago. The DOL resource guidance document, again, currently they're numbering questions 1 through 79, but the document is being added to frequently. So I would encourage you to check back with that regularly, and the IRS resource document, which will provide you with information on how you would seek compensation or tax credits for any amounts that you pay out under the emergency paid sick leave provisions. So with that, I think I'm just right at my 2 o'clock time. Thank you very much for being on the line today. I appreciate the opportunity to talk to all of you, and I wish all of you luck. I know this is a really stressful time for both employers and employees, and I'm happy to be here and be a resource for all of you.
Okay, thank you, Angela. Terrible feedback. There we go. Thank you again, Angela. I know what we'd like to do is at this time, if you have additional questions that you'd like to ask, we do ask first name, last name, organization name. Throw them in the chat box so that my team here at the Valley Chamber can follow up and get these circulate it over to Angela, and then we can also connect you via email with her there. I know one quick question that came in, Angela, will we be able to provide copies of the slides outside of just the video that we'll have posted?
Oh, yeah, I'm happy to email those to you, and you can distribute them to your members. Sure.
So we will circulate the slides with everybody who is on the call here. Again, I'll leave the call up for a few minutes here so you can type in any additional questions that may come to mind. We will have the video posted to the Greater Spokane Valley Chamber of Commerce YouTube page. So give us a few hours to get that posted and up. You'll see several other resource calls as well as our weekly joint chamber resource calls posted there, so you can go back and utilize those resources. Again, one point to emphasize here, everyone's case can be fairly unique to yourself, and so when it comes to this particular topic, what we do recommend is that you do seek out advice from your employment legal representatives if you have those. Otherwise, various organizations, we as a chamber have many members who specialize in this. Associated Industries is one of those members. Fantastic resource. I love that AI is a resource where you diversify some cost across a broader membership there when it comes to this, and so definitely something to look into. Moments where it becomes completely obvious that this is a necessary tool is moments like this in time. And so just again, certainly protect yourself as employers. Certainly our goal is to see every employer come out of this. There's a delicate balance there, obviously, between the employee and employer relationship. It does an employee no good if an employer is not there coming out of this crisis to continue to employ. So just be mindful of that, protect yourselves. And again, we'll leave this up to let you submit some additional questions there, and we will do follow-up following the call. So thank you all for joining us. Look for additional resource calls like this each week. We have a minimum of 2 or 3 of these going on every week, and so we're trying not to overwhelm you with resources in your inbox, but bring forward the ones that matter most in this particular time. So we welcome your feedback and appreciate your input as to what resources you need. We'll continue to bring those forward to you as Valley Chamber members. We appreciate your support. Obviously, in this time, choosing to keep up your membership with us helps me keep our team deployed to help you in the long run. And again, we will get through this. There is a horizon to this, making sure we're all there to continue business and pick back up where we left off. It was a really wonderful time in the economy. The quicker we get through it, the quicker we get back to those good times. And so again, stay healthy, stay well, enjoy your Easter weekend and the beautiful weather outside. Just don't be too close to one another. So Angela, thank you again to you and the team at Associated Industries for bringing your knowledge and making it available to our membership here at the Valley Chamber.
My pleasure. Thanks for the opportunity. And I was looking at the questions in the chat box. There's some great questions there. So I'm happy to, get responses back to you that you can circulate to the folks that were on the line today.
Perfect. Thank you very much. Again, everybody, we'll leave this up for a few minutes here to finish questions, and then from there, we'll be taking the call down, and we'll get you a link sent out to your email here before the end of the day. So thank you again for joining us. Have a great day.